Facebook blocks Charlestown, West Virginia City Council candidate's page with no further appeal. This is the censorship machine that is currently going on. So let's see. We got a new system that we are just setting up right now. So this will be our first use of this system. And I want to make sure we have it all working properly. So I believe we have Jason currently standing by. I'm going to be pulling him in now. Let's see if we can get this working properly. Get this up and running. And I believe we are loaded up. I believe we are just about ready to go. Jason, can you hear me? Jason, you there? There we go. Jason, can you hear me now? Nope. It appears we have Jason. Could not start the video, and this is what we get when we try and do new systems like this. Let's try and get it going again. Jason, are you able to hear me now? Nope. Completely broke. Let's see. It says it cannot be run, unfortunately. You want to try? We try and get a producer in here to fix it? Yeah. Did you know what the problem is? All right. Well, y'all can see him. Jason can't hear me, though. Oh, weird. So it defaulted that. Jason, can you hear me now?
I can.
Hey, all right. We figured it out.
Good.
What's going on, man?
Can't see you yet, but I can hear you.
Well, I don't think you'll be able to see me because of the way we got things set up, but welcome to the show. You're the first live formal interview that we're doing, and I know that you've got a big Supreme Court challenge coming up. We were just talking about Facebook censoring a conservative city council member who's running for election. Do you want to tell us what's going on with this Section 230 stuff?
Yeah, so yesterday it became official. We were docketed in the United States Supreme Court. We filed a petition for writ of cert. It's number 24-1116. And to summarize the petition now, because some people know what Section 230 is. For those that don't, it's the law that protects these companies from civil liability. That law has been misapplied by the courts for almost 2.5 decades. It was a mess. You know, we had the one show I came in and I explained a lot of it, but we figured out that, and see this, people need to understand how this translates, right? My case was about business, right? It's an antitrust. And the case, basically, Facebook came in and they wiped me out because they take money from my direct competitors to essentially manipulate the algorithm anti-competitively. Now, the thing is that that's essentially a viewpoint discrimination, right? It's just based on money. The translation here is that viewpoint discrimination, even built in the algorithm or the product design or however it is, yes, it is their First Amendment right to do so. But when they do so, they actually have to justify it under Section 230. The problem is that hasn't occurred. A lot of people are completely unaware that the courts are applying Section 230 as an immunity from suit, right? What I mean by that is that you don't get into court at all. They say you cannot be treated as a publisher, meaning the platforms, and you're done. That's it. And that's essentially what they said. They said that everything Facebook did is irrelevant because they can't be treated as a publisher because it was my content. Well, that's wrong. And it's wrong on so many levels that we can prove it in so many ways. For one thing, back in 2007, Judge Trauger out of Tennessee actually determined that Section 230 doesn't provide immunity from suit. It's supposed to be a justifiable protection. The thing is, if there's no justification, they can do anything they want. Well, there you have it. If these platforms can do anything they want with absolutely no accountability because the courts won't hold them accountable, they can censor any way they want.
So let's start from the beginning real quick. This is Section 2, Section 230. It's the Telecommunications Decency Act. Is I have that right?
Yes, it's a Communications Decency Act.
Communications Decency. It's been a long time since we covered this, but this was a huge story, 8 or so years ago, when this immunity was basically being used by big tech platforms to censor conservatives. The media lied about it the whole time, and they were trying to stop Donald Trump from having support. They were banning tons of individuals. They were proposing ideological rules. This was, of course, I had the moment on Joe Rogan where we talked about the misgendering policy, but this still exists. So is it my understanding that your lawsuit could do away with that perception of immunity?
It could change the world. It could change. And that's actually not an understatement. It's probably one of the most consequential lawsuits that nobody's paying attention to, and that's the reason why I'm dealing with so much opposition, is because it will change the entire economy. And here's why. If all of a sudden they are actually accountable for their own conduct, which is procedurally correct, it's based on the text, that's correct. The Ninth Circuit won't do it, right? So California, there's a problem in California courts, which of course, is always implied. We always kind of know it, but no, we've actually proven it. And here's why. We're not coming back to the Supreme Court this time with just our hat in hand and saying, this is how it works. No. In fact, the Third Circuit, Fourth Circuit, and Fifth Circuit have all said exactly what we have been arguing since day one in 2018. We were right. The court just won't do it. So the only court that can deal with a circuit conflict like this is, of course, the Supreme Court. That's why we're here.
What's the elevator pitch of your argument to the Supreme Court for the layman?
Elevator pitch. Okay, so there's 4 reasons that the courts are doing this wrong, right?
Well, so let's start with what is wrong? How should this work on the internet? What should be happening for the average person?
Okay, so this is how it should work, right? The platforms are supposed to be a neutral public forum, right? And what I mean by that is that they are supposed to act evenly across all boards, but if they censor, right? If they take down any content, they're supposed to be doing so in good faith. Everybody knows that, and people argue it's the terms otherwise objectionable. No, it doesn't matter, because if they don't actually get to court, meaning it's immunity from suit, you never have to prove that they acted in good faith, meaning they can do anything they want. Go ahead.
Real quick, it sounds like here's how it's basically been operating. Facebook will create rules where they're like, if you support, American natalism, right? If you think white people should have babies, you're a white supremacist, and we will ban you. And so they've enacted policies much like this, and we see this, frequently, especially in the past 8 years on Facebook. And the story today, of course, that I'm showing is they've banned a conservative running for city council in Charlestown, West Virginia, under false pretenses. And they can argue, we have the right to ban anyone we want and push forward any rule base we want and determine that anything we want is objectionable. So,
well, okay, wait. So let me interject something here. This is a good point. Who are they going to argue that to, Tim?
To the courts. Oh, you're right. To nobody.
They don't have to argue it to the courts because you never get in the door.
Exactly.
They never consider the facts of the merits. That right there is the fundamental problem. They don't have to argue that they did anything in good faith or that they did anything legal or otherwise, because the courts truly believe they cannot be treated as public.
So wait. This is really interesting then. The problem the problem we have right now with these big tech platforms is that while they do have correct me if I'm wrong, they do have some kind of protection, but you can never challenge whether they broke the rules because the protection is universal.
Absolute.
It's absolute.
Absolute immunity.
So
and the strange part is not only did the Tennessee court say that it wasn't immunity, the Ninth Circuit itself in Barnes held that 230C1 is not an immunity from suit. They're doing it procedurally wrong continuously, meaning they're doing it on purpose. So they're not applying it correctly and immunizing them when they want.
So would the ramifications of your Supreme Court suit be not that a company would lose Section 230 protections as they're written, but they would be subject to lawsuit to determine whether or not it does fall under Section 230?
You nailed it. The point is, it changes the idea that they can get out of suit entirely. It means procedurally, and this is proven. I mean, this case law proves this. You are supposed to, and this is the formal way. So any attorneys that are listening to it, it is to go from a 12B6 dismissal immunity from suit, meaning you never consider the merits or the facts. It's supposed to convert to summary judgment Rule 56. That was never done in my case at all. They never considered the merits. They didn't care what happened. If it converts to a summary judgment, then you get into what happened. Well, you're saying, well, they're arguing with somebody that they can do this or that or the other. With who? You never get to court. I never once saw a court.
When is your hearing taking place with SCOTUS?
All right, so this is the process. It is now formally docketed. Like I said, this is a monster. This is we have, and it's not to be discussed today, but I think you're going to see we're going to have a lot more support this time around, because a lot of people have recognized throughout the 7 years I've been in legal battle, we're right. The question is, if we go to the Supreme Court, right, and the Supreme Court, has to decide whether to hear our case. That's what's vital here. Everybody should be supporting what I'm doing. Everybody should be talking to everybody about it, because if the Supreme Court takes this case, our argument's indisputable. It's not whether we're right or wrong. We're right. All the court has to do, and this is as simple as it gets, Tim. I'm not even kidding. One sentence. If the court affirms that 230C1 is not an immunity from suit and does not protect any first party conduct at all, it resolves everything. It fixes the entire internet. It converts 230 back to the original way that it's supposed to apply, meaning they don't lose 230 protections. They will still have liability protections. What it does mean is they will actually have to do it in good faith. Wow. They will have to go after otherwise objectionable content. And if they don't and break a law, they go to court. And guess what? Then they have to prove it, as you said, but to an actual jury of their peers.
This is
now all of a sudden they're responsible.
It's fascinating. I deal with defamation all the time, as I'm sure you do too. And even with Times v. Sullivan and anti-SLAPP laws, you still get to go to court. You still get to sue. These are just protections they have. So for those that aren't familiar, let's talk about, like, Times v. Sullivan is a precedent that says that if you're, I'm paraphrasing, so, bear with me, I'm not a lawyer. If you're a public figure and someone defames you, you have to prove that they either knew they were lying or they were reckless. They had a reckless disregard for the truth. However, either way, if I were to sue someone for defamation, I get to file in court. I get to go to court. They just have the opportunity to issue a dismissal under that precedent, but they still have to send a lawyer in. So with anti-SLAPP, it's very similar. States have created what's called anti-strategic lawsuits against public participation. And the argument is, if you're suing a newspaper or suing someone for defamation, they can file anti-SLAPP to get the case dismissed. It sounds like what you're saying with Section 230 is they don't even give you an opportunity to argue. They just say outright, Section 230, your suit's gone, and we won't even hear what you have to say.
Correct. It is the equivalent of coming in there, you saying that they defamed you. And as you said, a lawyer has to go in. You have to have a hearing. It converts to a summary judgment. Now, it can be dismissed early under summary judgment, meaning if it's facially non-defamatory, all right, we don't need to go to court, right? It's essentially failure to show cause. However, in this circumstance, what I'm saying that occurred, it occurred in my case. It happened to me. The court said, we don't care about any of the merits. We don't care what happened. You cannot treat them as a publisher for their own publishing conduct. Goodbye.
So they didn't even let you make the argument then is,
nope.
Section 230 applies under certain conditions. And I argue they have not met those conditions. And the court basically said, we don't care what you think.
We don't care.
Bye. Dismissed.
Correct.
Can't sue.
Correct. You can't be a publisher. And
so
that
inherently
is the argument that everybody's struggling with is, are they a platform or are they a publisher? They are both. They are a platform, right? The dominant party, but they are also acting as a publisher. In other words, they're exerting their own First Amendment rights, but the court doesn't believe that they can be treated as a publisher simply because content originates from a third party. What if they change it? What if they let's just say, what if they recommend it, right? That's one that's confusing to everybody. Well, if they're recommending it, they're developing that information, right? Meaning they're picking that this information is good to advance or restrict. Well, as soon as they start to develop the information, they are exerting their First Amendment rights. They become an information content provider. That's the actual definition of it, which is a publisher. And meanwhile, the court says, we can't treat them as a publisher.
I just want to say, Jason,
they're a secondary publisher.
I just want to say, it's amazing how interesting you make Section 230. We had you on IRL before, and I was getting messages after the fact, and they were like, It's like court drama. It's really interesting stuff. I'll give you 2 examples of where I see the big problem with Section 230. And this is even outside of your argument. Yours is just, hey, let me sue, and a judge can figure out if I'm right or wrong. Yeah, let me in court. The first thing is exactly as you said. They pick and choose winners, so they've created an editorial guideline for people. If I made the joke before, I was like, how about I make a website, a news website? We'll call it the best news page in the world, everyone agrees.com. And then I'll let anybody write articles, but I will only put on the front page things that call Democrats evil.
Right.
Okay, so effectively,
that's content development. You're deciding what stays, what goes, what's advanced, what's recommended, what's restricted. That's content provision.
Imagine if the New York Times said, we're going to let anybody write articles for the New York Times. We won't pay you. And then we'll pick some of you to appear on the front page of the New York Times. They would then argue, nope, third party, we're protected. We're not a publisher.
Somebody else said it. We're not responsible for actually publishing it or putting it on or choosing. And it's like, yes, you are. And the problem is the courts still believe that, no, they're not. And it's, yes, as soon as they affirmatively act, meaning as soon as they get involved in the publication process, they're publishers. And the funny thing is, and this is really interesting for those that want to get critical. First off, I would suggest go to socialmediafreedom.org. Look at the last the petition. I'd read it if you really want to understand this. But here's the thing: the Fifth Circuit Court just in December, so this is recent, determined that just because publication exists in the chain of causation does not necessarily mean that the plaintiff is seeking to treat the defendant as the publisher or speaker of that content. They recognize the nuanced flaw there. Just because publishing happened. It's a publishing website. Of course it happened.
Yeah.
As soon as they do something, though, and you're saying that they did something, doesn't necessarily mean that you're trying to hold them accountable for what that content is. No. In fact, actually, in the Third Circuit, in a case called Anderson versus TikTok, they recognized, like, for example, they said what was it called? The blackout challenge. They said that, no, the plaintiff's not attempting to treat TikTok as the publisher or speaker of the blackout challenge. The plaintiff is attempting to hold the defendant responsible for recommending that challenge, which is its own negligence, its own publishing, its own First Amendment.
Well, what? And
the negligence to push that forward as a recommendation.
What was the result of that?
They understood the difference.
What was the result of that case?
They beat dismissal.
Really?
They beat the dismissal that I can't beat. The Fifth Circuit beat the dismissal. The Third Circuit, the Fourth Circuit, and the Fifth Circuit all beat the dismissal that I cannot overcome in California. Now, the craziest part, Tim, you'd think is because, and people argue, well, he's wrong. The courts have already determined this. No, the courts use things like, oh, I was untimely. Or the argument was... what were some of their arguments? Oh, it's irrelevant. They just completely ignored the case law. Said, oh, it's irrelevant. So they used procedural hyper technicalities that were completely wrong, and they ignored their own decision in Deep versus Apple. Essentially, the Ninth Circuit is sidestepping, correcting this, because as long as it remains ambiguous. Now, think this through. And, for your audience, Tim, think this through. The fact that it remains ambiguous in California, which is the main court that deals with this, right? They deal with 95% of social media law. The fact that they can apply it ambiguously, meaning they can hold you completely immune from suit. Facebook, Google, Twitter, they just can't be treated as publishers, or they can get it right in other circumstances and hold them accountable, meaning they have a leverage point. If big tech doesn't do what the government wants, it will hold them accountable. And if it does what they want, they'll immunize them from suit. Until the Supreme Court fixes that in place, that it can't be manipulated back and forth based on who the judge is or whatever, the censorship industrial complex will always continue to gain ground. That's how it occurred.
This is fascinating because it basically means, immunity is not going to change. If Rumble, for instance, if you get sued, you can file and say, I file a Section 230 dismissal or dismissal under Section 230. You'll get a hearing. The judge will then determine whether or not it does qualify as Section 230 or not and can move forward. There will be a lot more lawsuits, but you shouldn't be able to not get sued. You can't
circumvent law.
Right.
That's not right.
One of the most fascinating cases, in my opinion, which clearly shows Section 230 law is completely broken, is Wikipedia. Because I think we've talked about this before. Wikipedia is not like X or Facebook or YouTube. YouTube's going to make the argument, hey, that video that says Donald Trump is a donkey or whatever, we didn't publish that. We just allow people to publish whatever they want. So take it up with him. Right. Wikipedia, on the other hand, allows you to submit information to Wikipedia, and then Wikipedia moderators and people they've chosen with special abilities can determine if that appears on the front page of that article, which states a byline from Wikipedia, the free encyclopedia. Imagine if the New York Times said, we're going to publish a front page article on why Donald Trump sucks. Anyone can submit to us anything they want, and we will include it if we choose. Yes. You can't sue us now because John Smith is the one who said Trump sucks, not us. Right. That's laughably insane. But you can't sue Wikipedia because of Section 230. Here's the important factor in your suit. I've talked to numerous lawyers about specifically, not that I don't think it applies to me. I think my Wikipedia entry is, there's nothing in it that's over the top, defamatory and damaging, although it's not perfect and gets some things wrong. But James O'Keefe's is a really great example. It is ridiculously bad. I talked to a lawyer and said, what if James sued Wikipedia because that's their byline? And the response from every lawyer is, it will be dismissed instantly without argument because of Section 230. You won't even get a foot in the door.
Right.
How do you challenge?
And that is currently true, at least in California. It's not true in the third, fourth, and fifth circuits now, right? But reflexively, these judges are just tossing it because because the case law that has been established over the past 2.5 decades is done exactly that. It's turned it into an immunity from suit when it's not immunity from suit. And my circuit, when I was in the Ninth Circuit, they won't touch it. They will not let me in the door to fix it. So that is why we absolutely need the Supreme Court to step in here, because until the Supreme Court does, the judge ironically, the judge even said that until the Supreme Court weighs in on this, this is the final say on this matter, meaning even the court said until the Supreme Court fixes this, we can't get it fixed in California, meaning forget everybody's due process rights and their First Amendment rights. The courts are just circumventing them. So that's a constitutional violation too. I
think, in California, they're just cutting a sweetheart deal for these big tech companies.
Yeah.
So we'll see. But I got a couple questions for you. Do you think you're going to win?
If I am heard by the Supreme Court, it is indisputable. The argument is legally correct. There is no doubt about it. Anybody that reads it, you don't even need to be a lawyer. It's real straightforward. It defies the procedure. So civil rights, rules of civil procedure, it defies that. It defies the actual text. Remember last time, I believe we talked about a versus the, changing the definite article. Yeah. The actual language of the text, which you have to follow the law's actual text, defies what the courts have done as immunity from suit.
That was an interesting one too.
Section 230 doesn't mention immunity from suit. If it is immunity from suit, it means that the Good Samaritan general provision, meaning Congress's mandate, you have to be a Good Samaritan to gain protection, is completely defeated, meaning it actually violates the congressional intent. And lastly, if you cannot get legal remedy for someone restraining your individual civil liberties, which is exactly what they're doing, if you have no legal remedy as immunity from suit, that's a violation of the Fifth Amendment due process rights. I have a right to go after Facebook, and the courts are preventing me from engaging in that right. It is an unconstitutional mess.
That was a really interesting point you made last time you were on Timcast IRL, was that the A versus the A publisher and the publisher mean two completely different things.
Yep,
you can be a publisher of the content, meaning there's more than one, or the as the sole responsibility of that content, right, which makes for an interesting legal case. Now, a lot of people have said, "Oh, that's silly," but I think that will be interesting to get clarification. Last quick.
It's the text. You're supposed to follow the text.
Real quick, we've got about 2 minutes. Mm-hmm. If you win, what happens? How will the landscape change?
This is up there with Brown versus Board of Education. This will fundamentally change America. Censorship will die down dramatically. It will still occur, but it will occur in good faith if they seek legal protections. The companies that are not engaging in this kind of overt censorship don't need to worry, because they won't be held accountable. More lawsuits will occur. I mean, that's going to happen. And many of them are going to have to supersede a summary judgment hearing. The thing is we've at least got to get to a summary judgment hearing. So if this gets sorted out, it means that those lawyers that are saying you'll just get thrown out are wrong. And I'll actually add this. If you want to go after Wikipedia, and James knows me, even yourself, if you want to go after Wikipedia, oh yeah. The thing is, I act as an expert consultant for other lawyers that want to break through this, because although it has not been unified by the Supreme Court yet, we know it's right. We know how to fight it. And if you get a decent judge, you can actually get through this. The third, fourth, and fifth circuit has set precedent, meaning if you get to sue in those in those jurisdictions, you will make it through Section 230 now. It's just unfortunate the lawyers are just not aware of how it actually works.
Yeah. I'm surprised it's gone this far with Section 230 as long as it has, because it defies logic.
What's really strange is Justice Thomas himself has put out 3 different decisions in which he's calling for a case that is identical to mine. Mine nails it. This is the 3rd time we're going to the Supreme Court. It's indisputable. We need the Supreme Court to take this, period. It affects literally millions, if not billions of people worldwide, because it will change free speech in America overnight.
Interesting.
It's huge.
So it's been docketed, but I suppose the issue is they may reject it. They could say, we're not going to take this up.
Yep. And then meanwhile, the Supreme Court, and it's funny because there's lots of decisions that they go after and they take up cases. This one affects more people than any other case out there, because literally everybody uses the internet. And this affects everyone, because behind me, everyone else is sitting there going, we can't sue because the courts won't let us in, because lawyers won't even take it. It's basically a violation of due process, because it chills due process. It stops people from even holding them accountable. That's a problem. That's a big problem.
The scary thing, I suppose, is Supreme Court, they don't like taking up these big cases that have massive ramifications very often. So I suppose we'll see.
Nobody else can fix this.
Yeah.
The California courts won't fix it, and no other court can settle when we have here's where we're at. 3 circuits against the 9th Circuit. The 9th Circuit conflicts with the 9th Circuit. The lower court, district court under the 9th Circuit conflicts with itself. It violates the constitutional rights. It's violated my constitutional rights, and it affects every single American that is using the internet.
We do.
There is no other court other than the Supreme Court that should be dealing with this.
I look forward. I hope they do pick it up. Jason, it's been awesome to have you. We got to bounce, but where can people find you?
Socialmediafreedom.org. You can contact me through there. I'm also on Twitter at JasonFYK. My last name, Jason FYK.
All right, man. Well, thanks for hanging out. I really do appreciate it. And we'll hear from you next time.
All right. Thanks, Tim.
Take care. Ladies and gentlemen, absolutely incredible. And I look forward to what they're going to end up with. I look forward to seeing where he goes with that one. I think we need it. Section 230 is clearly busted, and it's high time we get some accountability. Now, if what he's saying is correct, that all that really happens is you are now allowed to sue, and they can seek a dismissal under Section 230, that will be tremendous, because it means you will get a wave of lawsuits, and there will at least be some concern from these companies. If we censor these people, we may win, but a lawsuit still sucks. Right now, they're basically saying you can't sue us no matter what, so what do we care? I look forward to seeing how that plays out. In the meantime, my friends, we are going to be sending you all over to hang out with our friend Russell Brand, who I believe is gearing up to go live right now. I believe Russell is just about up, and we're going to initiate that raid. Make sure to follow me on X and Instagram at Timcast. That was our first live interview, and I saw some people saying test live at your own, peril. We actually did multiple tests not live, and there's nothing you can do about it. The first run's always going to be that way. You see, we did have the system set up. It worked, but we're going to improve it. It actually is surprisingly more complicated than people realize to do these calls. I kid you not. It is stupid weird how hard it is. So, my friends, smash that like button, share the show. I believe tomorrow we are. I don't know how much I can say or should, because I don't know if we have confirmed everybody. But we're hoping to get Ben Davidson on to talk about the atmospheric phenomenon that caused massive power outages in Europe, because he's been warning about this. And then when these things start happening, you kind of want to ask him a little bit more. So we'll see. We'll be back tomorrow. We've got more segments coming up throughout the rest of the day. Then, of course, we're back at Timcast IRL, 8 p.m. My friends, smash that like button. Share the show with everyone you know. Thanks for hanging out. And we will see you all in the next segment.